Okay, it's 3:01, so we'll begin. Welcome to the next instalment of Contract Conversations. For those that are new to the series, it's a series of bi-weekly webinars being hosted by lawyers from across Mills and Reeve, where we discuss common issues which feature in contractual disputes, which people who operate English law contracts need to be aware of. Today, we're going to look at Endeavours clauses, why they're different from other contractual clauses, what common variations are and how they should be interpreted, some practical recommendations as well as what to do if you're negotiating a Endeavours clause or you're faced with one in terms of contractual performance. I'm Mark Davison. I'm the head of international arbitration here at Mills and Reeve, based in our London office. I'm joined today by Jonathan Christy.
Hi, I'm Jonathan Christy. So I'm in the commercial disputes team at Mills and Reeve, based in our London office as well.
So there is a Q&A function, so please feel free to ask questions. We'll try and deal with as many as we can at the end, as we usually do.
Okay, so I'll begin. As we all know, COVID-19 is wreaking havoc in the world at the moment. We heard from Rishi Sunak a few weeks ago that the unemployment rate is predicted to massively increase. The worst of the economic downturn is yet to come. So in particular, contractual obligations are becoming harder and more costly to perform, mostly in relation to COVID-related logistical issues. Increasing numbers of companies are expected to come into cash flow issues, which is often the reason for the non-fulfillment of contractual obligations. So the interpretation of the clauses that we're looking at today will likely be the subject of many disputes over the next year or two. Therefore, we thought it'd be useful to cover these areas now, as your businesses are likely entering into the relevant contracts from this point forward. So the general rule, as I'm sure we all know, is the performance of contractual obligations must be exact and complete. So most obligations, for that reason, are absolute. Silly example, I'm required by a clause to deliver a consignment of gold bars to Mark's house by helicopter. Whether I have satisfactorily fulfilled the constituent parts of that obligation can be determined objectively. The right amount and quality of gold bars, the timing and method of my delivery. And this form of obligation amounts to an unqualified obligation to achieve a particular objective, regardless of how onerous that objective is. So as a result of this, people giving unqualified undertakings, it's common in situations where parties can foresee an obligation becoming overly onerous or out of their control, to try to qualify that obligation with a best or reasonable endeavours clause. So this is where a party agrees to use some form of endeavours or efforts to achieve the objective, but does not commit to actually achieving the objective. Now, as a result, obligations that include best or reasonable endeavours wording are not so easy to assess whether they're being satisfactorily fulfilled, as at face value there's a bit of a subjective element to be assessed. So I'm sure between me, Mark, everyone else on the call today, we all have a slightly different opinion of what constitutes best endeavours. So the key question today is, how do you exactly and completely fulfill an endeavours clause? So put simply, how hard do you have to try? So today we're going to look at three different formulations of endeavours clauses, and look at the effect of each on the party required to perform the obligation. So the three that we're looking at are best endeavours, reasonable endeavours, and all reasonable endeavours. So the point to watch here is that, bearing in mind how these expressions have been interpreted in the courts, an obligation to use best or reasonable endeavours may be more demanding than expected. And then one of the points, we'll talk a lot today about obligors and obligees. Sorry, it's teacher grammar suck eggs, but what we mean is the obligor is the party who needs to perform, as in show that they have taken the right amount of endeavours, whereas the obligee is the recipient of that obligation.
Just before we go to talk about the clauses themselves, I just wanted to spend a minute just explaining how courts interpret such clauses. So what rules of construction do they apply? So first, in respect to the clause itself, it's probably no surprise, but the courts use normal rules of contractual interpretation and do this by reference to the meaning of the clause at the time that the contract was entered into. But when the courts come on to assess whether a party has done enough to comply with the clause, their assessment about the endeavours undertaken will be made by reference to the circumstances at the time of performance, no matter how unusual or unexpected they are. And that may sound a bit odd at first, but as some of the examples we'll come on to discuss, they show that it's fairly unsurprising given that circumstances of when a party needs to take endeavours to do something may have moved on from when they entered into the contract. I should add as well that there's been some instances of where courts have implied endeavours clauses. So, whilst it was a tax case, there was a recent case where His Honour Judge Berens decided in a case called SK Properties and Burn that a term that a property purchaser used best endeavours to complete a property transaction as soon as reasonably practicable could be implied, as it was synonymous with the rest of the contract and was one which an officious bystander would objectively deem needed to give business efficacy to the contract. Um, in respect to the clauses themselves, I think as Johnny mentioned, typically endeavours clauses are defined by using what we call best endeavours, reasonable endeavours, or all reasonable endeavours. And they all have their own standards of what's expected. And so what we'll do is we'll just quickly run through each in turn. So taking best endeavours, um, this is the most onerous standard of the three that we'll look at in detail today, and it's also the version which has received greatest consideration by the courts. So, what is it that you need to do in order to have used best endeavours? Um, Probably the best way to look at it is how it was described in a Court of Appeal case, a 1980 case called IBM and Rockware, where the court said that the obligor is required to take all those steps in their power which are capable of producing the desired results. So they must be steps which a prudent, determined, and reasonable obligee, acting in his own interests and desiring to achieve the result, would take. The way it was put in another case called Pips and Walton was that the obligor had to be doing at least all that a reasonable person reasonably could do in the circumstances. And so what's quite interesting about it is it effectively puts it in the viewpoint of the obligee of whether a reasonable obligee would have done everything which was reasonable in order to bring about the result. And so, whilst it seems quite draconian, the one point that I stress is what those quotes from those cases show, though, is it's still subject to reasonableness. So, it's not an absolute obligation to perform. There's still some leeway that there is some reasonableness in terms of whether you have to go above and beyond in order to perform. And so, just to give a couple of illustrations of this, in a 1974 case, it was called Malik and Central European Trading. There, the court held that a party could be required to use best endeavours to litigate or appeal a decision, but it would only go as far as to require that to the extent that such an action wasn't doomed to fail. So basically, if you've gone off and got advice that the appeal or the litigation is hopeless, you won't be required to go through with that process in order to use best endeavours to litigate or to appeal a decision. Another example is a 1990 case called Rackham and Peak Food, and the court held that directors could be required under a contract to use best endeavours to pass a resolution, but it wouldn't override the director's duty to act in members' best interests. And so it wouldn't require the directors to give bad advice to shareholders and to continue recommending a resolution once it ceased to be in the company's best interests. Um, I think probably as most of you on this call will sort of be aware of, the most common situation where disputes form about endeavours clauses is about how much a party has to spend in order to comply with their obligation. So I think this was most neatly summarised in a 2012 case called Jet2 and Blackpool Airport, where the airport had agreed to use best endeavours to promote Jet2's low-cost services. And what the Court of Appeal found was that in order to do that, the airport actually had to open outside its normal operating hours, despite the fact that it actually incurred a loss in doing that, because it needed to do that because it was important to Jet2 that it was able to schedule flights during those non-normal operating hours at the airport in order to further meet its business objective. But whilst the court said that even though that would result in a loss for the airport, the obligor could still have some regard to their commercial interest, and it wouldn't actually go as far as to say that a party would be required to bankrupt itself in order to comply with the best endeavours clause. So, the airport still had to have regard to its shareholders. But ultimately, I hope what you can see from the examples is that the steps which a party needs to take in order to exercise best endeavours does require a lot and is always assessed from the obligee's point of view.
Okay, so next we look at reasonable endeavours, and as you'd expect, they are less onerous than best endeavours. The crucial difference, and now we have a comparator between the two. The crucial difference is that reasonable endeavours would not normally include sacrificing commercial interests. So factors such as the obligor's relations with third parties, its reputation, and the cost of that course of action all need to be weighed up against the contractual obligation, the requirement to fulfil that contractual obligation. So this suggests that the courts will take an objective approach based on the perspective of the reasonable obligor. This is in contrast to best endeavours, where it's usually looked at from the perspective of the obligee. So that's taken to be in the circumstance and the position of the obligor. The chances of achieving the desired result is also taken into account. Therefore, once the obligor can do nothing more in terms of reasonable steps to achieve the objective, it is no longer obliged to try. For example, this obligation might not extend to taking legal action in a case where there's a doubtful outcome of that legal action, but that is not to say it would never require any legal action to be brought. And then lastly, any attempt by the obligor to manipulate events to prevent the obligation being satisfied will almost always be a breach of the reasonable endeavours obligation.
The last of the sort of commonly used endeavours clauses that we'll look at is all reasonable endeavours. And generally, I think it's seen by practitioners in the market that it's a compromise between best and reasonable endeavours. There's no direct case on point, but in UBH and Standard Life, it was said on an obiter basis to probably lie between the two. But then again, there was a 2007 case called Rhodia, in which it said, again, it was on an obiter basis, but effectively, depending on the circumstances, a requirement to use all reasonable endeavours may actually equate to that of using best endeavours. Oh, sorry, I've lost the slides.
Just trying to get our faces up again, aren't you?
I think that. So yeah, so whilst it's generally seen as a compromise, I think the most important aspect of when a party is required to use all reasonable endeavours is that it's not going to require the obligor to sacrifice its commercial interest to the extent that a best endeavours clause would require so. And that came from a 2010 case called CPC and Qatari DR. And so, whilst a party will still be required to incur expenditure in order to comply with an all reasonable endeavours clause, it's not going to go as far as requiring a party to incur expenditure which would sacrifice and defeat the purpose of the contract itself. And so, a useful illustration of this is from a case called Astor and Italia Mining, where Italia was required to use all reasonable endeavours to obtain senior debt facilities, which would then trigger the payment of a deferred consideration to Astor. What the court said was that Italia couldn't just go off in disregard of the clause and go and try and raise monies in a different way other than through debt financing, because that would defeat the purpose of the contract. But what the court interestingly said was that it didn't require Italia, though, to have to raise funds through senior debt if that would make their activities unviable, basically because the senior debt was so expensive to obtain. When we were discussing best endeavours before, I mentioned that the court construes it by assessing what a reasonable obligee would do. So it's assessed from the obligee's point of view. Whether a court will do this in respect of all reasonable endeavours, whether it references it from an obligee's or an obligor's point of view, is still uncertain. But I think, in short, what you can see from some of the examples that we've given, the requirement to use all reasonable endeavours, it probably doesn't go quite as far as best endeavours, but the threshold is still going to be quite high for you to meet.
So, I mean, those are the three that we're looking at. mostly, but there are other types of clauses that you would see, and often during negotiations, a party might look at a clause that says reasonable endeavours and say, well, I don't, I want them to be I'd like the obligation to be slightly more onerous than that, and they'll try to include some wording to reflect that. So there are several variations of the clause we've just gone through. For example, the terms commercially reasonable endeavours and reasonable commercial endeavours are often used to try and soften a reasonable endeavours clause. Similarly, the term utmost endeavours is sometimes seen as an advancement on a best endeavours clause, whatever an advancement on best endeavours is, don't know. There's little precedent to support a clear meaning of any of these variations, and one judge has noted that trying to ascertain a fixed meaning for any of these terms may have more in common with reading tea leaves than legal reasoning. So he was having fun that day. And I think that means that we just have to come back to the normal interpretation of the words in light of the interpretation of their variants, where they come from, and the contractual and party circumstances. So actually, in these cases where we have variations, I'd say it's even more important to focus on some of the practical steps that Mark's just about to spell out, so that you don't get bogged down in the potentially quite confusing wordplay. However, just before we get to those all-important practical recommendations, it should be mentioned that, of course, the clause also needs to be enforceable. And there's actually quite a few pitfalls in relation to endeavours clauses and on this enforceability point. So if the underlying objective is unenforceable due to a lack of certainty, an obligation to endeavour to achieve that end result will also fail. So, for example, in the case that Mark mentioned earlier, Jet2, there was a clause requiring Blackpool Airport to use all reasonable endeavours to provide a cost base that will facilitate Jet2's low-cost pricing. So Jet2 argued that what it meant by that was for Blackpool Airport to keep prices down to help Jet2 keep its prices down as a result of it. And Judge Morbick held that the words were too opaque to enable me to give them meaning with any confidence. And therefore, the underlying objective, and therefore the entire clause, was held to be unenforceable. Similarly, the combination of a less stringent requirement, such as reasonable endeavours, combined with a poorly defined objective, may lead to very weak obligation, and therefore, I mean, even though technically enforceable, is unlikely to give you the practical result you're after.
Yeah, just to add to Johnny's point about Jet2, it's if you're considering endeavours clauses, it's probably well worth having a look, because in Jet2 there was effectively two endeavours clauses. There was the first that I mentioned before in the section about best endeavours, which was the airport was required to use best endeavours to promote Jet2's low-cost services. And then there was actually a second clause, which was what Johnny just touched on, which was that they were required to use all reasonable endeavours to provide a cost base that would facilitate Jet2's low-cost pricing. And so it's quite funny that Morbick said that the first to use best endeavours to promote Jet2's low-cost services was sufficiently clear enough in order to give practical meaning to it. So therefore, that a clause was effective. But the second one about providing a cost base that will facilitate Jet2's low-cost pricing wasn't sufficiently clear enough, as Johnny just described. So that sort of actually neatly takes on to practical next steps. So in terms of what you should be doing with your contracts where you have endeavours clauses or where the other side has proposed one, I think as you've probably seen from some of the examples that we've given, that the fact that the circumstances will affect how endeavours clauses will be interpreted, I think the key takeaway, which I'd ask people to take away, is that if you can spell out what needs to be done, then do so. So, for example, that Jet2 in that case could have easily sort of said what the airport needed to do to help provide a cost base that would facilitate Jet2's low cost pricing. In terms of just specific examples of the way that you could spell it out of what a party needs to do, so whether an obligor's got to bear any costs or incur any expenditure, do you want to set out how much they're actually supposed to spend? the period for which an obligor should pursue a particular objective, is it worth specifying that within the agreement? If the obligor's got to take legal action or appeal to achieve the objective, is it worth spelling out what sort of prospects of success that course of legal action should take? Um, I think another interesting aspect is actually, do you want the obligor to inform the obligee about the progress in meeting its objectives, so that the obligee is kept apprised of what is happening, and also then set out, if the obligor can't succeed with its objective, whether or not actually you want the obligor to stand aside and allow or even assist the obligee to solve the problem itself. It's probably also worth considering, when you're looking at such clauses, whether or not you should actually spell out the extent to which a party is entitled to protect its own commercial interests, or is actually required to act in the interests of the other party, or base its actions on its own particular circumstances. I think, as hopefully you'll have seen from the cases, it's not usually about whether a party was required to do something. The disputes are always about whether or not that party has done enough in order to comply with the provision. If you're already involved in a contract at the moment, and there is a Endeavours clause and you're needing to comply with that, one of the things you might want to consider doing at the moment is just actually documenting what you're doing and why, just so that you've got that contemporaneous record for if there is a dispute later. But obviously, just having the back of your mind that anything which is produced now is unlikely to have any privilege attached to it, so that might be disclosable to the other side in any resulting proceedings. Also, if you're sort of having a problem with complying with an Endeavours clause, just have a look whether there are any other provisions of the contract which may assist you. So a useful illustration of this at the moment is probably in respect of COVID-19. So if you're having a problem with trying to act with Endeavours at the moment because COVID-19 is preventing your performance in one way, would, for example, a force majeure clause help you? So if you take the JCT contract, which is a standard form building contract that's generally used in the UK, that usually requires contractors to act with best endeavours not to cause delays. But similarly, those contracts tend to contain force majeure clauses, which typically provide that a force majeure event caused by a government act which prevents performance may excuse the party from its performance. So you might just want to have a look whether actually a government lockdown has meant that you've not been able to perform, and you therefore might have an argument to be able to rely on a force majeure provision. But obviously, always have in the back of your mind that usually, in order to rely on a force majeure provision, parties have usually got to take steps to mitigate the consequences of the force majeure event. And very finally, if you're negotiating the clause itself, if you're going to be the party that's going to be performing the endeavours, then obviously try and go for the least draconian. Try and say that you use reasonable endeavours in order to comply. But similarly, if you're going to be the one that's on the recipient end, so somebody's going to perform for your benefit, then obviously try to go for the best endeavours will give you the most protection. So just in respect of questions, having a look. So there's one here about, so have the courts given a view on how much you should incur to comply with an Endeavours clause? Again, I think, as we've sort of said through the examples that we've given, it very much depends on the type of clause that you've got, whether or not it's a best or reasonable endeavours clause, and it'll also depend on the circumstances and the financial situation which is being faced by a particular party, and the courts will also take into account whether or not the requirement to incur such expenditure will actually defeat the purpose of the contract. Taking that Italia mining case into example, but to answer the question, that there isn't a sort of a strict definition or formula as to how much a party needs to comply. It will very much depend on the clause and the circumstances which the parties find themselves in. Johnny, do you want to take the next one?
Yeah, so there's a question here. What is required in a scenario where specific steps are set out as part of the exercise of reasonable endeavours? So is the obligor obliged to carry out those steps, or only exert reasonable endeavours to carry out those steps? So the answer, I mean, I guess it will depend on the wording of the clause. But on the face of it, if the requirement to carry out reasonable endeavours to achieve an end goal, and the steps to reach that end goal are defined as part of what constitutes reasonable endeavours, I mean, it almost becomes a defined term in that case, and those steps will need to be carried out. Those steps will become a constituent part of reasonable endeavours. So yeah, there's not just a requirement to carry out those steps, or give reasonable endeavours to carry out those steps, but those steps must be carried out, as that will fulfil the clause.
Okay, perfect. I think that's all we've got in terms of questions. If you've got any questions which you'd like to follow up with Johnny or me after the session, then please feel free to ask. Again, I'll just if you've not already done so, then please feel free to connect with us on LinkedIn using the QR codes there. Similarly, if there are any other topics that you'd like to cover, like us to cover during this series, then please do let us know. We're more than happy to receive particular topics which are of particular interest to people at the moment. That is the last in the Contract Conversations series for this year. We're going to take a break for Christmas, but we'll carry it on in the new year, and we'll follow up shortly with the topics that we're going to cover off at the start of next year. Hopefully when you leave this seminar today, there'll just be a quick poll of 2 questions to fill in, which would be grateful if you could answer. In the meantime, appreciate it's a bit early on the 8th of December, but Merry Christmas and Happy New Year. Take care.